I wanted to give a brief introduction to the members of this conversation who I am so excited are joining us. The first is retired Third Circuit Judge Tim Lewis, who is currently a partner at Schnader Harrison. He is an avid triathlete too. And I am very excited that he will be joining us for this conversation. I will tell you the opinions that he gives are those of his own and not those of the judiciary. So we are all clear where he's standing. We are also being joined by Professor Linda Greenhouse, who is a lecturer at Yale Law School, and she covers the Supreme Court for the New York Times, and I am truly honored that you are here with us today, so thank you. And our third, I'll say, discussion person is Professor John Watson, who is a tenured professor in the journalism division at American University, and he is a journalist and attorney. And actually, Linda, you are too, right? Am I wrong about that?
I'm not a lawyer, no.
Okay. Oh, one non-lawyer on our panel. So I want to thank you all for joining us. And I'm going to start off this conversation with, I'll say, a softball. And, you know, the public's trust in institutions has been decreasing in the past, in recent times, I'll say. And unfortunately, the trust in the judiciary, right, is at an all-time low. The concern with misinformation or disinformation being distributed by the press and the media is also out there. And I am wondering, you know, why each of you thinks the situation exists and what your feelings are on it. Judge Lewis, do you want to begin?
I will begin because you have suggested that I should. Otherwise,
I'm sorry.
Thank you. First of all, no, that's quite all right. First of all, thank you very much for inviting me to be here. It's an honor to participate in this event today, and also to share some conversation time with my esteemed colleagues here this afternoon, this morning. I don't know that I would call it a softball because it actually gets right to the heart of some very deep and serious issues that we face as a nation. I think that in a very broad sense, the answer to your question is the reason is because we are still engaged in what Lincoln referred to at Gettysburg as our unfinished work as a democracy. And as a matter of fact, that work has become just all the more difficult over these past years in which what I think is really the underpinning of our democracy, that is a common faith in our institutions, has experienced severe devolution. Why is that? Well, it can be attributed to, it's not the first time, obviously, and I think it can be attributed to a number of factors. They do go back in years when we were talking about the judiciary. And I should also say that this is not the first moment in our history when obviously not when the judiciary has been under such direct attack. In our recent history, of course, there's the Southern Manifesto in the wake of the Brown versus Board of Education decision and other decisions by the Warren Court. There have been times when the judiciary writ large and the Supreme Court of the United States have been the subject of a sort of a sense of outrage that I think is rooted in a failure to appreciate the importance of maintaining faith in our institutions, and whether we agree or disagree with certain decisions, so that the Senate is involved here, the Senate Judiciary Committee is involved here, the failure to grant to even have the decency to grant now Attorney General, then Supreme Court nominee Merrick Garland a hearing is implicated here. The the tone of Senate Judiciary Committee confirmation hearings is implicated here. I'm reminded of Linda Greenhouse's colleague at Yale Law School, Stephen Carter's observation many years ago that the confirmation process for Supreme Court justices has devolved to the intellectual equivalent of a barroom brawl. I mean, this has rankled people and groups and so forth for many, many years. Throw in the Federalist Society and the impact that organization has had on the selection of federal judges and Supreme Court justices. Throw in the reverse approach by the Senate Majority Leader in connection with confirming a Supreme Court justice during an election year. I mean, it just goes on and on and on. And then we add to that the very divisive commentary and politics that has beleaguered our country for these past number of years. So it's a big question, actually. Why is that? I mean, there's so many reasons that it's very easy to point to decisions by the Supreme Court, for example, and to blame it on ethical challenges, perhaps, of Supreme Court justices that I'm sure we're going to talk about and what they mean and how they influence and impact the public's sense of the or faith in the judiciary. I will end this part by just saying that it's kind of ironic because I've had the honor of serving as a federal judge on the district court and the Court of Appeals. I've had the very high honor of knowing a number of state court judges and justices and other federal judges and Supreme Court justices. These are people of the highest integrity, by and large, in my experience, who work very, very hard to get it right, whether you agree with their decision or not. And I happen to think that the past couple of years may stand as the finest hour in the history of the federal judiciary in terms of how federal judges have stepped up to protect our democracy in the wake of January 6th and other events. There are outliers. There are judges who have done things that have raised eyebrows, of course, but so there is some irony because I think that what we have actually witnessed should give us all hope and enhance our faith. So thank you for asking that question, but it's not a softball.
Okay, sorry about that. Okay, thank you. Professor Greenhouse or Professor Watson, what are your thoughts?
I agree with what Judge Lewis said, and I'll kind of synthesize it by saying that the fact that the court has become the political prize in our system, because those who've been driving the forces that he accurately described are not able to accomplish what they want to accomplish through ordinary democratic processes, through legislation, because their goals are not the goals of the American public. So we have a Supreme Court that's been driven to a series of decisions that the American public doesn't want. And so, not that most people spend most of their time pondering Supreme Court decisions or reading Supreme Court opinions, but let's take Dobbs. Let's take the elephant in the room, which is abortion. And at the time of the leak of Dobbs in May of 2022, something like 70% of the American public did not want to see Roe against Wade overturned. And they made that quite clear. In the immediate aftermath of that leak, there was a huge uproar in the country to the extent that the court felt it necessary to put up an impenetrable 8-foot tall fence around its building. There were so many protests going on. But yet, of course, the leaked opinion in Dobbs within 2 months had become the official opinion in Dobbs. And public esteem for the court, trust in the court, continued to plummet. And, you're quite right, Deborah, to say that public trust in all our institutions of government and in the media have fallen in recent years, but the court has fallen faster and had further to fall. The court was always safely, one might even say maybe smugly, held in high esteem by the majority of the American public. And that's not true now for the complex of forces that I think Judge Lewis accurately described.
Thanks. Professor Watson.
Yeah, I think that in both instances, the loss of respect for the court system and the media is based on greater knowledge of what's going on there. The more we know, the less we defer to. When the Supreme Court was this highly secretive group of people in robes who were essentially, announcing the equivalent of religious doctrine, they were highly respected. But as we came to know them more and more as human beings with foibles and leanings in one direction or another, the respect and deference necessarily fell. I mean, the more we know that people are like us, the less reason we have to put them on a pedestal. And we judge them the way we judge our peers. We look at what they do and we gain or lose respect for them based on that. Now, whether the American public as a whole has lost respect, I would say yes, but I would say it's almost half for one reason and half for the exact opposite reason. For many people, particularly people looking at the US Supreme Court, these are politicians in robes. They are following a political agenda. Now, that may or may not be true, but the news media has framed all of these legal issues as political, cultural issues. And I'm not saying that's bad, because what other frame do we have? That's how we have to look at courts, any form of government, as a tool that we are supposed to use to improve, our lives in this country. If these tools seem to be working at odds with what we think is best for the country, of course we lose respect for them. Okay, we own the country. In a democracy, the country is supposed to do what we want it to do, and whenever it doesn't, it's malfunctioning. And those people who are running these institutions are at fault. And of course we lose respect for them. Now, I'm speaking simultaneously about the news media as well. The news media is divided into at least two camps. And very close to half of the American public thinks one is carrying us off to hell in the handbag, and the other half says the other side is carrying us to hell in a handbag. And the answer, I have no idea.
It seems like the curtain for the judiciary, for the media, has been, opened by the internet, let's say, right? We used to not have the internet. We only had 3 television stations. We only had a few newspapers. Now people don't read papers. They look at they get their information from the internet. So, there are more choices and more information available, which helps formulate, I'll say, more opinions. But but I know that I know Judge Lewis may take issue with your comment about politicians, that judges are politicians in robes, because I know a former Chief Judge of the Third Circuit Court of Appeals would go around saying, that's the one thing that really gets me is, there are the media is calling a judge an R judge or a D judge. Judge Lewis, do you have anything to add?
Well, it may surprise you to hear that I do not entirely disagree with John, first of all. But with that having been said, I don't know which Chief Judge of the Third Circuit you're referring to. I had the privilege of serving with someone who became my mentor in the federal judiciary, the greatest circuit court judge in the history of the country, as far as I'm concerned, Ed Becker. And Ed Becker Ed Becker had no problem saying openly and publicly, we are a policy-making court. You can say whatever you want. That's what we are. We are a policy-making court. And the truth of the matter is that the circuit courts, by and large, and U.S. Supreme Court, the high appellate courts are largely policy-making court. Justice Sotomayor, then Judge Sotomayor, got in a lot of trouble for comments along those lines when during her Senate Judiciary Committee hearing, but she was just telling the truth. I do agree that there are obviously there are politics involved in the selection process. There are politics involved in what judges think, and sometimes and that can influence judicial behavior and the development of jurisprudence. But it's also true that elections have consequences. I mean, it's kind of a hackneyed. That's true. I mean, we have seen that Trump had 3 appointees, and when I vote, I'm just going to share with you a personal thing. When I go into the voting booth for a national election, I'm going to tell you, first and foremost, I'm thinking about the United States Supreme Court when I vote. Now, I don't know that a lot of people do that. I do know that a lot of my Republican friends do that because they've told me they do that. And so this is one of the consequences. Obviously, when a president makes these appointments, the president is going to try to find folks who reflect that president's perspective. So yes, of course, there are politics involved. If I may just quickly share with you some observations I made just to kind of distill what I think about this. Back in 2020, shortly after the George Floyd tragedy, and in the wake of all of that, I made the observation that in 2007, the Chief Justice of the United States, and I think it's important to note here that I said a man of immense decency whom I respect, and I mean that, I do. It indulged in willful blindness, in my judgment, in response to an effort to achieve diversity and open doors of opportunity that our dark past had bolted shut with the infamously hollow phrase, "The way to stop discrimination on the basis of race is to stop discriminating on the basis of race." In my view, when he wrote those words, Chief Justice Roberts was, with surgical precision, conveniently excising the history of this nation from present-day reality. I then followed that up with some comments about his observation in Shelby County versus Holder that our country has changed, and legislative remedies to address racial discrimination must speak to current conditions. I mean, in my view, this history major from Harvard and esteemed graduate of Harvard Law School betrayed a complete lack of understanding of the history of our country and current realities in those phrases. But I didn't disagree with his heart. I mean, I know that he was doing his best to reflect what he honestly believed. And I think this is the key. I don't indulge in, and I hope that reporters and commentators and others can try to find a way to refrain from demonizing because we disagree. I think it's perfectly fair to call out judges and justices on their jurisprudence. I think it's a different matter to call them out as individuals and human beings as being flawed personally in whatever ways they might be. I mean, I just don't think that is helpful, and I think it contributes to the first question you asked, which is, what happened? Because that's what we do now. We demonize when we disagree, and I think it's terribly unfortunate. The Pennsylvania Supreme Court. I'm from Pittsburgh, and I'm sitting here in Pittsburgh right now. Our Supreme Court a few years ago issued an order requiring the Republican-controlled state legislature to turn over information about the gerrymandering, because there was a case about a constitutional issue. And the president pro temp of the state Senate refused to do so and said, I think that's an unconstitutional order. I'm not going to comply with it. The U.S. Supreme Court upheld the Pennsylvania Supreme Court, and that in turn caused a Senate Republican leader to move to impeach the 5 justices on the Pennsylvania Supreme Court who were in the majority in that decision. I mean, this is what I'm talking about. I just think that we if we can just find a way to have faith in whether we agree or disagree with the decision, in the folks that we have entrusted with this authority, then we might be taking a step forward. Both the media, the public at large, commentators, and even folks who are holding office. I'm sorry to spend so much time on that, but I just wanted to get back to John's observation about politics being involved, because he's absolutely right. But I think that there are reasons for that, and there are limits to what we ought to do about that.
So if I could just add a footnote to John's comment about, maybe the problem is we know our judges too well now, and in the past they were just sort of anonymous figures in robes. Actually, just as a footnote, looking at the U.S. Supreme Court, in the past, the justices were actually quite well known in the sense that they were taken from electoral politics. So Earl Warren, 3-time governor of California, had run on the Republican national ticket for vice president on the Tom Dewey ticket. He was a very well-known public figure. The reason President Eisenhower put him on the Supreme Court was to get him out of Republican politics as a competitor. And it was, in fact, the early Warren court did not have a single member who had ever served as a federal judge. I mean, that's remarkable from today's perspective, where basically anonymous federal judges are elevated to the Supreme Court. I'll make one more comment, that technology can be our enemy. Technology can also be our friend. And technology has actually made the courts more transparent than they've ever been, in the sense that many state courts and some of the lower federal courts, I believe, televise their arguments. The Supreme Court now has live streaming audio of all of its arguments. That would have been, that's an artifact of the pandemic, but that would have been remarkable even 5 years ago, and somebody can go on the court's website, supremecourt.gov, and see all the briefs, transcript of all the arguments up the same afternoon as the argument occurs, all the opinions going back, so that, speaking as a former journalist, there are many more resources now, and people need to avail themselves of those. And I think one antidote to the demonization that Judge Lewis is properly talking about, and that is a problem, is it's certainly not the role of the press to demonize, obviously, but it is the role of the press to explain and excavate the origins of cases. For instance, what's this case doing there? Why did the court take this case? Where does the court think it's using this case as a vehicle to drive toward, and so on? I mean, that's the obligation. And if from that excavation and observation comes a notion that, hey, there's something a little fishy here, let it speak for itself. It's not up to the press to characterize, but rather to just put it out there and let people, empower readers and viewers to, with the information, that they can come to their own informed judgments about what they're seeing and hearing.
So my concern, is that, yes, there is information out there, but the media and press don't have the time or don't really delve into, all this information that's out there. So we have 800-page opinions. So how do we have the coverage that is necessary to inform?
Well, I don't think we have 800-page opinion. We do have some long.
We do have some.
They feel like 800 pages.
Yeah, right. Well, I mean, that's a failing. I think, it's very popular now. There's a whole dialogue going on now that, the Supreme Court press corps, just a bunch of lazy good-for-nothings who revere the Supreme Court and don't tell us the truth, and so on and so on, which I reject. But I think if any part of the press is at fault in how legal developments are transmitted to the public, it's the publishers and editors and news directors. It's not the individual reporters, because you're quite right, Deborah. This is a serious job, and people who are in the front lines of doing the job, that is to say, the working reporters, have to be given the tools and the time to do that. So the publishers and editors and news directors have to prioritize meaningful, not just name calling, meaningful coverage of legal developments. And if they don't, shame on them. And that's a problem for our democracy.
Yeah, Professor Greenhouse, I think you hit the nail directly on the head with respect to the functioning of the news media in this. Coverage of the Supreme Court should be as detailed and vigorous as coverage of Congress and the White House. Dahlia Lithwick just wrote an article. She didn't call Supreme Court correspondents lazy, but I think historically they have been much too deferential to the court. Maybe it's because they're afraid of losing access, which they never really had to a great extent. But lately, the most important incisive news stories about the court have not come from the Supreme Court reporters. They've come from outsiders, particularly those who are focused on political reporting. Now, the framing, of course, is political, but the information has been accurate, okay? And I keep referring to the term framing. The simple fact of the matter is you cannot tell any story without a frame. What really counts is the frame you choose. So if you're a reporter from Politico and you're exposing misbehavior by the Supreme Court, I would expect you to come at it from a political frame, okay? If you're a reporter from another beat outside of the Supreme Court beat, and you're used to covering crime or corporate malfeasance, that's almost certainly going to be the frame. But generally, when a reporter has a beat, she is the one who uncovers the most important information about that beat. I've had the pleasure of knowing at least two people who covered the Supreme Court, and they were not lazy. They were extremely bright, but they were extremely deferential to the court. They were reluctant to do what reporters I had covering City Hall in New Jersey, who would do it in an instant without even being told to find out what's really going on. Now, this is not going to improve the public's respect, but I think journalists have to do their job. And I think if people are going to get respect, they're going to have to earn respect, and that respect is going to have to come from what they are actually doing and how what they're doing is being framed, particularly in the news media.
Okay, so if I can respond to that, lazy is not the word. I'm very familiar with Dahlia Lithwick's, with Slate's project, and I don't understand this accusation of deference. I honestly don't understand it. I used to cover politics in New York. I was the chief of the New York Times Legislative Bureau in Albany. And there, of course, covering politics, you rely on sources. And it was a lot of fun, and I had a lot of sources, and I really enjoyed it. I was a baby reporter. I learned a lot. I came down to Washington to cover the court. And the first thing that struck me is I had nobody to talk to. I had no sources. Now, that's very liberating, because if you have no sources, you have no sources to lose. You have no sources to lose. You call it as you see it. You do the deepest dive you can possibly do on how the court is handling its highest obligation, which is to establish its docket and decide its cases and tell the country what the law is. I don't honestly know where deference comes in. It's kind of, the Slate project is kind of picking low-hanging fruit, actually. But the notion of losing access, there is no access. That's the challenge of that beat, and that's why it's different. And that's why the politicos and the ProPublicas can do the job they're doing. They don't have the obligation. Those folks don't have the obligation of actually telling the public what the court is doing in its public function. And there are two sides to that coin, and all of it ought to be out there. But to say that the reason that the beat reporters are not doing that is because they're deferential just doesn't make sense to me.
Well, see, when I was a city editor in New Jersey, if my City Hall reporter didn't get sources, I wouldn't accept there are no sources. Journalists live or die by their sources. The quality of their reporting is intricately tied to their ability to get sources. So deferential may not be the right word. I think it's a term I embrace because very often the people who cover the Supreme Court are lawyers. And you learn from law school to kiss the ring of the man or woman in the robe. And it's hard to throw that out when you're in the highest court of the land.
Well, I sure didn't feel that my ring was being kissed when I was a federal judge. I can assure you of that. But I do understand the point. This discussion, I mean, obviously, Linda and John have the expertise when it comes to covering and sources and reporters and so forth. But I would say that I think that when we are talking about the Supreme Court as opposed to local common pleas courts throughout the country, state Supreme Courts, lower federal courts, we're talking about different reporting here. I mean, we're just talking about a really entirely different forms of reporting. And I will say to you that my best friend, when I was a federal judge, was the reporter. I mean, he personally, is my personal best friend, was the reporter who was assigned to cover the federal courthouse by the Pittsburgh Post-Gazette. He just happened to be my close friend because we became friends when I was an assistant U.S. attorney, and we would talk and have lunch and so forth and so on. So when I went on the bench, that didn't change. Now, I wasn't sharing inside information with him, but I do think that it's important to have, for judges and for courts to have some sort of comfortable, if that's possible, relationship with the media. I mean, in terms of talking and discussing in general issues, responding to questions, and getting to the question that Debbie asked about 800-page opinions and the complexities and so forth. I think it's very helpful to the media and also to just the public at large. If judges would do what Judge Becker taught me to do and what I see some of my former colleagues continuing to do, and just summarize the case in a very clear, concise, short sentences, opening paragraph. And so the reader, and actually Judge Aldiser, a former judge on the Third Circuit, mentioned this in his wonderful textbook on judicial writing. And so if I can then decide as a judge, as a lawyer, as a member of the public, as a member of the media, do I want to read the rest of this opinion? If you will just lay it all out for me in one paragraph, I think that would also go a long way. But it's important that there be some sort of dialogue with the media. I'm really I don't know much about the project that Linda, that you were just talking about. I did read the article that you were referring to, John, but it just seems to me that it would really be healthy for the Supreme Court, for other courts throughout the country, and for the media to be on this, pardon the pun, the same page in terms of just sharing enough information that people can understand what's going on and what the issues are that they're grappling with.
I agree, and I've written about that. But you had a friend. You were not his source. That's what I meant.
That's right.
I didn't mean that.
No. I don't think judges should be sources. I don't. I mean, I think that judges should speak. I guess I'm old school in this sense, through their opinions. Although I do think that it would be nice if they could be open to being interviewed on occasion about things that they think about, what they do at home, just who are you? I mean, the only time we get to learn that about Supreme Court justices is at their Judiciary Committee hearing for the most part, and that's staged. But
Well, so just Stephen Breyer, when he was on the court, he came from politics. His favorite job was to be when he was chief counsel under Ted Kennedy of the Senate Judiciary Council, and he had a quite refined sense of politics. And every year he would invite the Supreme Court press corps out to lunch, and at a local, usually Indian buffet restaurant on Capitol Hill, and just kind of, he was taking the press's temperature just as the press was taking his temperature. And, that was like a good thing. No inside information was exchanged. He probably learned more than we did, but no, I totally agree. There ought to be, exchanges on a human level. I don't want to be misunderstood, but when I said I had no sources, I didn't mean I never talked to a Supreme Court justice, but nobody ever gave me the inside scoop on what was going on.
I also think that judges should not be afraid to tell the truth when they are in an open setting responding to inquiries. And I'm sure that most of us read Judge Ponzer's piece, in which he very accurately laid out the concerns that other federal judges have about the ethics issues at the Supreme Court and problems that it is causing throughout the judiciary. I raised the same issue at the Third Circuit Judicial Conference and was told by the moderator of the panel, who was a judge on the Third Circuit, we are an inferior court and we can't really respond to that sort of thing. Well, I mean, okay, I hear you, but you actually can. And judge, I mean, I just think that this sense that judges it gets to the kissing of the ring point. Judges are somehow removed from any ability to respond directly just because there's a reporter there, and just be open and honest about what everybody knows and what everybody is concerned about would be helpful. So anyway, I am an advocate for a more open dialogue because I think it would be good for the public. I think it would address the problem that Debbie opened us with, and I think it would be healthy for the media too. Now, that doesn't mean that the media. I may read an article about a Supreme Court decision in the Washington Times that will have a completely different take than the Washington Post, or in this. And I do. I read as many as I can. But and so, whoever's reading is going to get a different perspective on what the justices are doing, or what they said, or why they said it, and how bad it was, or how good it was, or whatever the case might be. But that's democracy. That's okay.
Yeah. I really appreciate what you said about judges talking to reporters, not on the record, but explaining what a case is about without going into the parties and the positions, but just the general area of legal knowledge. And that was what I was trying to do in New Jersey. And I did find a judge on the appellate level who I could have that conversation with. And I think it was primarily because we went to the same law school, though not at the same time. Now, years later, I was at the Freedom Forum. There was a off-the-record meeting between judges and journalists. And I mentioned that fact. And there was a judge, and I use this term guardedly, who lost his mind and demanded that I identify this judge who spoke to me, who I never attributed to, but who helped explain to me what was going on in the case. Not talking about any position of either party, but just explaining it to me. And I remember how horrified I was some years ago when the Supreme Court issued a decision and all these reporters were running around trying to report what it meant in a minute. I mean, and that was so unnecessary. This decision probably had been written for a few months, all right? And to make the reporters try to tell the American public what it meant in a minute was just torturous, un-American, undemocratic. It was foolish. And I blame the news media for that. They place this horrible value on speed. And the first impression you get, if that is wrong, I have a PhD in communication. it is almost impossible to change a first impression. If the reporters get it wrong the first time, even if they try to correct it later on, the correction never bites as deeply as the original report. And the reporting on what the Supreme Court does is too important for the first impression to be wrong. But the way these decisions are released, the way this is such a secret until that instant when it is released, it doesn't make sense. It doesn't serve the American public's understanding of what the law is or the rationales behind it. Journalists can be trusted to embargo things. And I think the most responsible news media would agree to an embargo if the purpose of the embargo is to add to clarity and efficient news releases. Okay, and I was just appalled by judges who just find that to be heresy. And I apologize again for the religious reference, but.
Well, I mean, I tell you an anecdote. I wasn't involved because I was long off the beat, but when Obamacare, the first Obamacare case, when the fate of Obamacare was hanging by a thread, it was obviously the big case. And it was the last day of the term. So obviously that was the decision that was going to come down. I am told that the publisher of the New York Times went into the newsroom and said to the team that had been assembled to cover this, I don't care if we get it first. I care that we get it right. And, you know, that was a very empowering thing. And the Times did not get it first, but the Times got it right. Whereas the Los Angeles Times and a bunch of other major news organizations got it sooner, but they got it wrong. And anyway, I just throw that out there as an anecdote. I mean, the press has a responsibility not to feel that it has to jump at the first moment. And the internet has made that problem a lot worse because everybody's got to post the story to the website. And fortunately, I didn't have to do that. But, and I don't think I would have been so unhappy at having to do that I would not have continued on the beat if that was the case. But it's a two-way obligation, and the press certainly has an obligation.
So it's interesting. We're talking about the Supreme Court and reading, right, the opinions. But, you know, there's also many other judges. There are also, you know, now I'll say trial by media implications. And, you know, how does that factor into, I'll say, the uplifting or downlifting, decreasing the confidence in the both the judiciary and the media?
May I ask I'm sorry, Linda, please go ahead. I didn't quite understand what trial by media, what you were referring to.
Well, I'm just saying, like, there's all this, you know, you have, I'll give it like the Johnny Depp trial and the memes that were out there and the takes and the publicity ahead of time and the publicity afterwards.
Okay.
You know, it influences the public. But that's what I was referring to. Sorry.
Yeah, I think it's hard to generalize.
Yeah.
I mean, some cases and some trials are just inherently super newsworthy. Some are kind of, you know, the celebrity, you know, business. But I personally don't actually see that as a major problem.
And I don't either. I will say what I said at the very beginning, which is that I have really had the very high honor in my professional life of knowing a lot of judges and lawyers, of course, too. And by and large, and for the most part, these are people of the utmost integrity, and they are not influenced by. They are not influenced in their decision making by what you are referring to as trial by media. So, to the extent that there's a question as to whether or not that plays in the court, by and large, I'm not saying there aren't exceptions. We know some. There's some very recent significant exceptions, but by and large, no, they're above that. Judges are above that, by and large, I think.
Yeah, trial by media is a term that is negatively framed because it gives the impression that the journalists are determining the outcome of the case. if there's a trial and a judge is swayed by media coverage, that judge shouldn't be on the bench.
Right.
I mean, a public official who can't do their job publicly shouldn't be in that position. But unfortunately, many of these media trials are focused on issues that aren't really important, but are very interesting to the public. I would have loved to see deep coverage of the web design case from the very beginning. That would have been something I would have loved from the instant the first complaint or the first court document was filed. And that would have been important to see how that progressed. I mean, important.
There was never a trial in that case.
Yeah, I know, but the first document, there was things that would have been educational to the public, and to follow it into the Supreme Court, I think would have been so educational as to be unprecedented.
Now, I will say that on the flip side, I perhaps some would disagree with what I did in this instance, but I think judges can do certain things in what they might view as worthy of public attention, matters that might be worthy. When I was a trial court judge, and I had to impose a mandatory minimum sentence on a first-time offender who was only 18 years old, and it was 10 years. I called the editor of the local newspaper, and I said, I would like for you to make sure that you have a reporter in my courtroom this afternoon, because something awful is going to happen, and I want to make sure that it gets wide coverage. And I did that because I just felt that this was a terrible thing and that people should know about it. Now, is that bad? I mean, was that wrong? I don't think it was wrong. I'm sure there are some who would criticize me for that, but so when there are significant matters that either side recognizes as being important, I think that we can work together to try to do our jobs and at the same time stay in our lane.
Clearly, someone would say that showed your political bias. I would say it showed you're a human being with natural blood in your veins and a heart that beats it. But
and how do we get more judges to speak to, and this is my last question because I know we've run out of time, but how do we get, more open lines of communication?
Well, there's a so-called baby judge school that's run by the Federal Judicial Center for newly appointed judges. And back in the day, they occasionally invited me to talk to these so-called baby judges. And I would say really what I distilled from the conversation that we had, which is don't be afraid to get to know the people that cover your courthouse and, establish a relationship of trust. Not that you're going to give them inside information or they're going to demand it, but you're going to get to know them and maybe teach them a few things that will enable ultimately the public, which is the purpose of the whole enterprise of journalism, right? Enable the public to understand what's going on in this very important institution. Whether any of them ever took that advice, I have no idea.
And it's interesting, and I'm going to do an advertisement, but PMC actually has held a table talks program for state court judges and reporters to have off-the-record conversations where we have, a breakfast and we have judges and journalists and media at the same table. And I don't know what comes of it. I've never asked, but I'm hoping that a more open, relationship has resulted from that.
Mm-hmm.
So I want to, go ahead. Go ahead.
The Reynolds Center in Arizona had been doing that for a number of years as well. I don't know if they still do it, but I went to a couple of them and they were very good.
Yeah. So, all right. Well, I thank you all for this lunchtime conversation and your participation in PMC's One Day Law School. I don't think there can be enough of these conversations. I agree. We should be allowed to disagree, right? And I think it's really important. So thank you very much. And we'll be moving on to our next panel.